Okay, so I'm Andrew Brookes and I am a solicitor and partner at Anthony Gold Solicitors in Warworth Road, London. So I was contacted at the start of the crisis by a concerned resident, and really it went on from there, and colleagues as well as me have been to public meetings, to advice sessions, and we've been contacted and instructed by numerous residents with regard to the issues in the estate. Well, if the deadline passes for things like getting a cooker, then first thing I would do would be to complain, preferably in writing by email or text or something that you can refer to later on. It might be difficult in the short term to insist on that, but in the longer term, for tenants who are going to take compensation claims, things like those sorts of delays will tend to go to increase the compensation. The answer to whether they can force entry to the flat is that they can do so only in very limited circumstances. The tenancy agreements say that Southwark can force access in an emergency, and an example of that might be if you left the taps on and it's flooding out your neighbour below. I don't think that it is an emergency here where there are planned works, and I don't believe that Southwark can lawfully force access. If they do force access during the course of these works, then I think that's something you should take up with the council, and it is something that you should obtain compensation for. Can you be reimbursed for loss of earnings for taking time off work? Well, ordinarily, for routine appointments, the answer would be no. However, there are a couple of things that we can say about that. First is that for residents who take time off work and the contractor doesn't turn up, or the contractor is delayed, and so you miss time for that, then I definitely think that you can claim compensation for that time. In this particular situation, where there are rigid periods where Southwark are demanding access, and quite a lot of access as well to put in the temporary heating works, I do think that that might mean that residents can additionally seek compensation if they've lost earnings for that time off work as well, but I doubt if Southwark will voluntarily agree to that. Southwark have already offered some very nominal compensation for loss of heating. In my experience, they're unlikely to offer substantial sums without being pushed to do so, and there's a legal process in place whereby residents can do that, but although they can do it themselves, most residents might want to take the benefit of legal advice to do that. The payments that are being offered at the moment, the small payments for not having any heating, etc., residents can accept those and bank those payments, firstly because they're not expressed to be sort of in full and final settlement of any claim, so they're not signing away their rights by taking that money. They would of course have to take that money into account in any further compensation claim, but it seems to me that that's likely to be only a small part of the compensation they might be entitled to. Would you have to go to court if you want to claim compensation? Well, it is a legal process, but having done literally hundreds of these claims over more than 20 years working in Southwark, I can say that only a handful of these sorts of cases actually go to any sort of court hearing, and that the overwhelming majority are settled in out-of-court settlements, and that is what I would expect would happen in the case of Ledbury tenants and leaseholders as well. I can't 100% promise that, but as I said, from the benefit of experience, that's the likely way things will go here. So some important questions about how long the compensation process will take and how much you might get, whether it will be paid into your bank account. Well, certainly it will be paid into to your bank account, usually, well, certainly via solicitors first, but then paid into the to the claimant's bank account. How long does it take? Well, it's likely to be a minimum, I would say, of a matter of months, perhaps up to maybe 18 months if the process becomes very extended. It's very difficult to give a more accurate estimate than that, really, because it depends on factors outside of our control, like how long Southwark take to respond to things, like how long the court takes to respond to paperwork, and also there's a timetable set out in the rules as well, which mean that there is a time scale sort of built in of several months at a minimum, really. But of course, it's in everyone's interest to try and press this forward as quickly as possible. So perhaps I should talk a bit more about how much residents might get. Now, there are specific expenses. We talked about loss of earnings that residents might have suffered, and there might be items damaged, that sort of thing, extra heating bills, all that sort of thing. But they are likely to be the smaller part, and the major part of the compensation is likely to be for the inconvenience, distress, etc. of having to put up with cracking, leaks, uncertainty over an extended period of time. Now that's based on a rent rebate, like a percentage of the rent that you've paid. It doesn't matter whether it was paid by partly or mainly by housing benefit, it's the rent figure that you paid. And for tenants anyway, that can go back for 6 years if you've been there for 6 years. Of course, won't be a full rent rebate, it'll be a part rent rebate, but that can mount up over it, particularly if someone's been there and particularly badly affected for a long period of time. So we can be talking about thousands. So what impact does the fact that we now know that residents have been living in danger with these cracks and the problem with the gas supply have on a claim? Well, obviously it has a significant impact in that this is all about residents' voices not being heard, and it's a theme which came through in Grenfell. It's a theme which has come throughout Britain, really, for social housing tenants in particular, and it will of course be a factor which will impact on the compensation that people might be entitled to. But as I said, compensation would be calculated on an individual basis based on an individual's personal circumstances as well, so it will be a combination of the two. Is it too late to take a compensation claim after you've moved out? Well, absolutely not. You don't suddenly lose your right to compensation for having to put up with the conditions in the Ledbury block after you moved out. Excuse me. You continue to have those rights, and you can take a claim. There is a long stop. There is you can only claim for back for 6 years, so it is important, I think, to start that process rather than wait. Otherwise you might lose part of your claim once you've moved out, but you certainly can take a claim once you've moved out, and there's nothing to stop you doing that. So for leaseholders, can they force you to move out or force your tenants to move out? The simple answer is no, they simply cannot do that. The only situation where they could do so is if there was a compulsory purchase order, and there isn't a compulsory purchase order, which can only follow a long legal process. So as we speak, there is no way the council can force a leaseholder or their tenants to move. As far as temporary accommodation for leaseholders is concerned, and of course we're talking about resident leaseholders here, my understanding is that the council will temporarily rehouse leaseholders in much the same way and under much the same criteria as they will for tenants. So that involves contact with the council and has the same problems but also advantages that it does with tenants, really. So are there any difference in rights between resident leaseholders and non-resident leaseholders who are landlords, say? There are some similarities, but there are some differences as well. As far as differences are concerned, I suppose the principal one is that non-resident leaseholders wouldn't have a claim for inconvenience, distress of having lived in the Ledbury towers. So that part of it that they wouldn't have, but they would perhaps have the same claims for loss of value of the property potentially, and also for additionally perhaps for loss of rent if they lost tenants as a consequence of all of this. It's correct that Southwark have promised that they won't charge a service charge for these current major works. I think having made that open promise, if they change their mind later and tried to charge leaseholders, it would be a defence to any legal proceedings, or alternative leaseholders would say that it's not reasonable in the tribunal, because there's another way of challenging service charges. So one way or the other, I think that open promise having been made, it would be legally enforceable. Leaseholders can absolutely make a compensation claim, just as tenants have, or just as tenants can, and that claim, at least for resident leaseholders, can very much like tenants be for the for the inconvenience, distress of having lived in through this current crisis and the preceding problems. Additionally, they may have claims if they've a loss of value of the property, and also possibly for loss of rent if you had lodgers or were renting the property out. So can leaseholders insist on selling back the property to the council, and how do they get a good price? Well, there isn't any statutory obligation on the council to buy back properties. However, I understand that the council are considering that option and are formulating some proposals as far as that is concerned. And we'll have to see what that is, but people may be aware that leaseholders on the Haygate and the Aylesbury estate and other redevelopments, there are and have been buyback schemes of varying quality which the council have put forward, and it seems likely to me that any scheme that comes up here will be similar to those sorts of schemes. So can the council do a compulsory purchase order or CPO? We're absolutely miles from that at the moment. That whole process is a very lengthy process involving a consultation and inquiry, and would only be in the instance where the blocks were going to be demolished and we are very far away from that at the moment. That's not been suggested by the council, and that you as leaseholders can't insist that they go down that road at the moment, and it rather depends on what happens next. So can leaseholders do an equity transfer or sell? The answer is yes, they can in theory. Whether any buyer or person that you're transferring to will want that, or will be prepared to pay the price that you want to sell for is another matter.
Okay.
So leaseholders have asked whether they can insist on being transferred to another leasehold property or council property, and whether they can then buy that. Those sorts of issues are all involved in the buyback scheme, and as I said, Southwark are apparently going to come up with some proposals in that regard. Certainly those sorts of themes and issues formed part of the buyback schemes in the other estate redevelopments in Southwark. So some people have asked whether properties have been missold, and as Southwark didn't mention the structural issues when they bought them. There may be a claim against the council if you bought something for a certain price which it wasn't actually worth, and the council should have known that. That's possibly a bit early to say, and something which we'll need to see what the Arup report says when that comes out. But that is an issue, and that is something that leaseholders might want to pursue. Yeah, some leaseholders have said their leases differ from other leaseholders. While there are different forms of lease, they're all basically the same, and they're all Southwark's standard right to buy leases. They've changed over the years, but the basics are the same, and the basics in terms of the rights and obligations of the council are much the same in all of them. So although there are some small differences between them, I don't think there's going to be anything which really makes one leaseholder's situation different from another. So some leaseholders might have bought their property direct from the council using the right to buy, and some leaseholders might have bought it from another leaseholder. In that situation, there are a lot of rights which are the same. So particularly if you've lived there as a resident leaseholder, whether or not you were the original purchaser, you still probably have a compensation claim, as we've discussed. There might be some differences depending on what the council said in the offer notice, sometimes called the Section 125 notice, to do with the price and the what works Southwark said were outstanding. So there may be some differences, but there are a lot of similarities as well. So some leaseholders have asked whether they could commission a second opinion on the Arup report if and when it comes out, and I suppose this is a question equally relevant to tenants too. There is of course nothing save the cost of it for leaseholders and tenants commissioning their own report into the conditions in the towers, but I suppose there may be some practical issues about getting access to parts of the building which aren't, actually one of the flats involved, and there may be issues as well about, the sheer cost and the extensive work that might be required. However, of course, finding someone who might want to comment professionally on what Arup have written and interpret it is another matter, and that may be a much more realistic exercise for the leaseholders and tenants as well. Can residents, whether leaseholders or tenants, force Southwark to commission a further report? given that Arup got it wrong in the past, is, I think, a difficult one, and the answer probably is no. At the end of the day, I don't think there's any sort of legal mechanism to force the council to do that, and it's very tricky, I think, to insist on that. It's more a question of holding them to account, perhaps getting another expert to provide an opinion on what's been written, and to question and to probe that way, rather than having the right to actually force them to get another report.